Chapter 9 looks at eyewitness testimony and accuracy. So, there are approximately 4,500 innocent people convicted every year due to mistaken eyewitness identification. And these types of errors are responsible for more wrongful convictions than all other cases combined. And this is because juries and the public tends to think of eyewitness testimony as the most reliable testimony there is, that it's the most powerful evidence. It's so powerful that people often change their verdict from not guilty to guilty based on this. Jurors tend to overbelieve and heavily rely on this types of evidence. Now, in 1985, Kirk Bloodsworth was convicted based on the testimony of 5 eyewitnesses. And DNA on the victim's clothing in 1993 showed that he wasn't the source of the semen on the victim's clothing. And in 2003, they were actually able to match the DNA to the actual murderer. So, during the first half of the 20th century, we see several psychologists scientifically studying the foundations and applications of cognitive processes to legal issues. They're looking at perception and memory, suggestibility, confessions, lie detection, and hypnotism. And in 1900, Binet advocated for the scientific testimony of study based on eyewitness observation. And he felt strongly that eyewitness reports were affected by suggestive questioning. But it's not until the 1970s that cognitive and social psychologists start to show a heightened interest in this topic. So, what can psychology tell us about eyewitness identification and accuracy? In the 1970s, Buckhout is one of the first social psychologists to research eyewitness recall and memory for people and unconscious transference. Now, unconscious transference is the generation of memory that's related to an incident but is not actually relevant to that incident. So in 1974, Buckhout stages a mock assault in front of some unsuspecting college students. And 7 weeks later, he asked them to pick the assailant from a group of 6 photos. Now, 60% of them did not correctly identify the assailant, and 2/3 of those chose an innocent bystander. Now, several factors play a role here in our ability to accurately identify witnesses, um, or accurately identify suspects, or in eyewitness identification. That includes stress, the physical condition of the witness, suggestive identification procedures, and conformity. And Buckhout argued that we should make sure that juries are aware of this, that any eyewitness report should be evaluated cautiously, and his findings have been affirmed by many others in other research. So, in terms of perception and memory, we make perceptual errors all the time. We over or underestimate someone's age, their height, their weight, how fast something is going, our distance from something. And the process of acquiring new information, keeping it in our memory, and then using it later consists of 3 things: encoding, storage, and retrieval. So, encoding is the actual acquisition of information. And as an event becomes more complex, some portions are probably going to be wrongly remembered. Stressful events heighten our awareness and interest, but extreme stress will usually cause an error with encoding. Now, Yerkes Dodson law says under extremely low levels of external stress, a person may be so relaxed and unalert that little learning takes place. When facing an excessively stressful situation, our perception is narrow, information is funneled, and less learning occurs. So, our performance is best when that level of arousal is moderate enough to ensure adequate attention, but not so high as to disrupt accuracy. Characteristics of the witness also affect encoding. Basically, we have a tendency to see what we expect to see. Now, that next step is storage, actually building memory. So, this is activities that eyewitnesses carry out or information they learn after they observe an event that can really alter their memory of the event. So, viewing mugshots can then interfere with our memory of what we saw before we viewed those mugshots. Now, retrieval is the recall of information, and this can be influenced by how we ask questions. And language can influence this. So I could ask you, how far was the car going when it smashed into the other car versus when it contacted the other car? So eyewitness testimony is affected by both estimator and system variables. Estimator variables are attributes of the person and the environment. Am I making a cross-racial identification? Am I fatigued? What's the lighting like? Am I under stress? System variables are things inherent to the justice system, how witnesses are interviewed by the police, and how witnesses are instructed prior to actually viewing the lineup. So, in terms of estimator variables, when we make cross race identifications, they are less accurate. A chance of misidentification is 1.56 times greater when making a cross racial identification, whereas a same race identification is 2.2 times as accurate. Stress affects accuracy, and there's also what we call a weapons effect. So, if someone is brandishing a weapon, we have a tendency to focus on that weapon, which makes it harder for us to then recall details about the offender. And now, more recent research has said any surprising object can actually have the same effect. Exposure duration is positively associated with the ability to identify an offender. The more exposure we have had to that offender, the better we are, the more likely we are to be able to properly identify them. And obviously, disguises affect our accuracy of identification as well. Now, systems variables are the manner in which eyewitnesses are interviewed. So, cognitive interviews, as we've talked about before, allow for more accurate witness statements. And the current form of doing this incorporates some social psychological aspects of face to face verbal interaction with what psychologists know about the way we remember things. So, first, you want to start by engaging with and establishing some rapport with your witness. Then, ask your witness to provide a narrative account of the event. Then, probe with questions relating to the details the witness provided. The interviewer wants to interrupt as little as possible, allowing the witness to dictate the subject matter and the sequence of questioning. And your job then as the interviewer is to actively listen. And really, the direction the interview takes should be guided by the witness's pattern of recall. Now, lineups. A lineup is when a suspect is placed among distractors and the witness is asked if they can identify the suspect. Now, these can become problematic because sometimes law enforcement officers give unintentional clues as to the identity of the suspect. These can be verbal clues, body language, or encouraging words. So if you tell the witness, wow, you did a great job, you're going to imply to them that they have chosen the right person, and that's going to make them more confident in their identification. Now, this happens because both the witness and the police officer want to solve the crime, and because we're also suggestible. Individuals have a tendency to accept uncritical information during questioning or complying with what they believe the interviewer wants to hear. Now, in a double blind lineup, the person who administers the lineup does not know who the suspect is. In a photo spread, we typically see the suspect and the foils at the same time. But a better method is to show them sequentially. This is allowing the witness to take each photo and compare it to their memory of what they saw. And it decreases the likelihood that they'll choose somebody because that person looks most like the suspect. Now, it's important to make sure your lineup isn't suggestive. Suggestive lineups happen to have problems with heterogeneity. So we want to make sure that all the foils look pretty similar to the suspect. We want to inform the witness that the suspect may not be present, and ideally, we want to use a sequential lineup. So, what does the law tell us about eyewitness identification? In 1967, in U.S. v. Wade, the Supreme Court held that the suspect has a constitutional right to the presence of a lawyer during a live lineup. Now, in 1962, they reversed this and said only when an indictment has already been handed down. In 1973, they said you don't have a right to counsel at any identifying procedures because we could reconstruct those at trial and analyze whether or not they're too suggestive. In 1972 and 1977, the Supreme Court lays out some factors that determine whether or not they consider an identification to be reliable. One is the witness's opportunity to view the criminal during the crime. Two, the length of the time between the crime and the identification. Now, those two pieces we have research that backs up. The Supreme Court also wants us to look at the level of certainty demonstrated by the witness at the identification, the accuracy of their prior description of the suspect, and their degree of tension during the crime. Now, after some concerns about this, Attorney General Janet Reno, who was Attorney General under President Clinton, wrote a guide for the conduct for initial reports, composition of mugbooks, witness interviews, field identification, and lineups. The first step is to ask open-ended questions and not ask leading questions. We want to remind our witness that the offender may not be present, select fillers who fit the witness's description, and record the witness's own words regarding how sure she or he is of any identification. So, what are some things we can do to try to um, ameliorate problems associated with eyewitness identification and lineups? So, in a trial simulation, participants were asked to assume the role of jurors while reading a written summary of a trial, hearing an audio simulation, or viewing a video simulation. And then they report their verdicts. Jurors were not sensitive to the importance of information that affected eyewitness accuracy and appeared to pay little attention to these things when evaluating evidence and rendering verdicts. So, some ways that we can try to deal with this is we can file a motion to suppress. This is a legal device that's used to prevent evidence from entering a trial. So, we could try to suppress somebody's identification. During voir dire, so when we're selecting our jury, we can survey and inform the jury about the sources of eyewitness reliability, the ability of jurors to differentiate accurate from inaccurate eyewitnesses, and the probabilistic nature of factors that influence perception, storage, and retrieval of information. We can also use expert witnesses. We can ask them to come in and testify as to the reliability of eyewitness testimony in general and the construction and composition of lineups and photo arrays. These witnesses should be prepared to discuss the strengths and weaknesses of the data on which they're basing their opinions. And if done correctly, this does enhance juror sensitivity to factors that influence witness and identification conditions. We also want to make sure that we cross-examine the other side's expert witnesses and witnesses. If we don't challenge that expert witness, if we fail to cross-examine them, the jury might assume that we accept and believe what that eyewitness has said. Sorry, what that expert witness has said. And that wraps up chapter 9.